today's topic is the Anti-Defection Law. I remember starting my teaching career with Anti-Defection Law in 1985 when the law was made and 86 when it kicked into operation. I'm still teaching from law to the lawlessness. Today, the Anti-Defection Law is in use for all the anarchic reasons, for all its malfunctioning, for all the looking for the loophole, exploiting it, and also the court's verdicts at times not in line with the law. All that we will see. We will begin with, obviously you are expecting me to focus on para 4 that deals with the merger, and I promise you I will. I will at a length much more than your expectations. But before we get there, we are used to building it up from basics. Basics are very important. And from there we will take it forward, and I will surprise you with more and more constitutional and judicial details. So, we will start with Anti-Defection Law. Why was it made? It was in 1985, 52nd Amendment Act, which brought in the 10th schedule. I must tell you, it returned the 10th schedule. In 1974, if you recall, while making Sikkim a part of Indian Union as an associate state, the 10th schedule was introduced. But when Sikkim became a fully fledged state the next year, 1975, the 10th schedule had no relevance, so it had to be discarded. And in 1985, it had staged a comeback with an entirely different content. The content relates to the Anti-Defection Law. Remember Aaya Ram Gaya Ram culture, where legislators elected on one party ticket were changing their party and joining a party that they opposed while contesting just for certain personal benefits, opportunistic. And this was called horse trading, and that was a black mark on our democracy. Therefore, it had to go. Representative honesty, electoral integrity, political stability, and morality. This is what the Anti-Defection Law aims to achieve. That's why it was enacted. Now, anyone who violates the Anti-Defection Law is a defector. Is a defector? That means he has to be disqualified. So who is a defector? Any legislator who changes the party, voluntarily gives up the party on whose ticket he is elected, is a defector. An independent who joins a political party after his election while being a legislator is a defector. So these are the two defectors. But there are some exemptions carved out. I will talk about exemptions a little later on. So what happens if you are a defector? You get disqualified. I will talk about the consequences of disqualification, comparing it with the consequences of resignation. While legislators prefer resignation, but the law, the Supreme Court says that, the High Courts of Karnataka and other states also say that, while a case is pending against you with the Honorable Speaker for disqualification for defection, if you resign, that resignation letter will not be entertained. We'll come back to that. That's also a hot button relevant issue today. Now, so there are defectors. Who is not a defector? Let's get to that. Who is not a defector? Speaker, Deputy Speaker, Deputy Chairperson of Rajya Sabha, and their counterparts at the state level, Assembly and Council. They can leave the party and return to the party without attracting the provisions of the Anti-Defection Law. Why? They are the presiding officers. They should rise above party politics. They belong to a political party, got elected on the strength of a political party association and membership, but while being presiding officers, they should give the impression that they are above politics. Unfortunately, quite often we see that they are not adhering to the norm of impartiality. That's an exception. That's another story. So yes, they can leave and come back. Remember, I didn't say chairman of Rajya Sabha because chairman is not a member. He's not a member of Rajya Sabha. So chairman don't tick because that may come in the prelim. One of the following can leave and come back and he'll give you all the four. Chairman is the odd guy out because the chairman is not a member of the house. Now the point is, so this is one carve out, one exception. Another is a nominated member of Rajya Sabha can join a political party. He gets 6 months within which to decide, and after 6 months he is a defector. Within the first 6 months he can exercise the option of joining a political party. He won't be a defector if he does so in the first 6 months. There used to be a window called split. 1/3 of the legislators, for example, ABC party has 9 MLAs, 3 of them come out and the 3 becomes a split. All the 3 escape the disqualification, defection provisions. That was a split. But then you wanted to prevent individual defection and you ended up creating en bloc defections, wholesale defections. Therefore, the 91st Constitution Amendment Act deleted split, and split is no longer valid since 2003 when the 91st Amendment Act removed the window for split. So split is not valid anymore. If 1/3 come out, they are all defectors. Then there is another provision for merger, which is the focus of today. Merger is in the para 4 of the Anti-Defection Law. Merger. That means 2/3 of the members of the legislature party. That is, if there is a party with 9 legislators in Lok Sabha and 6 legislators in Rajya Sabha, and in the Rajya Sabha 6 of them decide to merge with another party, neither the 6 are defectors nor the 2/3 are not defectors and the 1/3 are also not defectors. All of them are considered non-violators. None of them has violated. So this is a merger, but around the merger there is so much of unnecessary controversy. You will see it in the graphic about the merger. What's this merger? Very, very simple. I'll take you back 15 years to 2011. The Praja Rajyam party of the mega star Chiranjeevi from Andhra Pradesh, Telugu. He is a Telugu film actor who is a mega star. He floated a party called the Praja Rajyam Party, later found that his ideology and Congress are convergent, almost identical, social justice and so on. Therefore, the party took a decision, we are merging with Congress. And all their MLAs, all their MPs, all of them had become members of the Congress party. Automatically they don't become. Only when 2/3 or more of the legislature party, the legislators of a political party in a house are the legislature party. In that 2/3 pass a resolution saying we are merging with another party, then the 2/3 become members of the party with which they have decided to merge, and the 1/3, if any, they also remain members. But in the case of Praja Rajyam, all of them decided to merge. There is no 2/3, 1/3. So that is the most peaceful decision of a political party, major political party, merging. We have seen a recent case of Trinamool Congress merging with Nationalist Citizens Party of India. That's a nondescript party. 2/3 decided to merge, and the legalities of it are being gone into, etc. We'll have an occasion to come back to that. So, merger is given in para 4. Para 4 has 2 sub-paras. First para says that if the original political party decides to merge with another political party, in that case, in every state assembly where there is a council, the council, and at the union level, the Lok Sabha and Rajya Sabha, there are legislature parties. 2/3 of the legislature party, if it decides to merge, then the 2/3 escape anti-defection law, 1/3 also. If the original political party decides to merge and none of the legislature parties moves accordingly, then all of them remain members of the legislature of the old political party. The old political party may not exist on ground, but all its members, unless they wanted to merge by a majority of 2/3 in the case of each legislature party, they remain members of the old political party, which does not exist on ground. Now, so the original political party takes a decision, the members and general body meeting and the leadership and office bearers and all that, they decide to merge. If that happens, then each legislature party has the option of 2/3 approving the merger and executing it, and 1/3, if there is a remaining 1/3, or all of them join or 1/3 doesn't. In this case, all of them remain members of the legislature. So there are two sub-paras here. They are connected. They should be read conjunctively. In other words, sub-para 1 leads to sub-para 2. Sub-para 2 does not exist independently. If 2/3 of the members of the legislature party decide to merge, they cannot do so unless the original political party has taken a decision to merge. If para 4, sub-para 1 is non-operational, sub-para 2 does not exist. Sub-para 1 is operational, sub-para 2 kicks into operation, 2/3 of the legislature party of both the houses of parliament independently and in every state, etc. So, but the wording of sub-para 1 and 2, particularly sub-para 2, is a little confusing. And there is a temptation on the part of few scholars to read sub-para 2 independently of sub-para 1, which should be impossible. Only conjunctive reading is allowed, and separate reading of the two sub-paras of a single para, how could that be allowed? I can't understand. So there is this para 4. Regarding para 4, there is some jurisprudence. There is a case law. Case law. There is a Bombay High Court Goa bench, and there is of course the Supreme Court Subhash Desai. I'm going to discuss both of them very clearly with associated legal phenomena. First, let's start with the Bombay High Court Goa bench verdict 2022-2025. In 2019, in the Goa Assembly, 2/3 of the Congress party took a decision to merge itself with the BJP. That was in 2009. That was in 2019. And the same was taken up it was challenged. Surely the Congress leaders will challenge it. Girish Chodankar and Mahadev Nayak, Congress leaders, they went to the Goa bench because it happens to be Goa Assembly. And the Goa bench of the Bombay High Court said, read paragraph 2, the law is very clear, the deemed merger, the legal fiction is that 2/3 of the members of the legislature party decide to merge with another party, then everything is hunky-dory. Why are you here contesting it? Have you not read para 2? That was the verdict, Girish Chodankar, verdict 2022, Bombay High Court, Goa bench. 2022, that was early 2022. Again in the next legislative assembly, the 8th legislative assembly of Goa, in 2022, after the coming of the verdict, there was a new assembly constituted. In that, once again, 2/3 of the members of the Congress party decide to merge with the BJP. Then the Congress party again challenged, went to the Bombay, they went to the speaker. Sir, what is this? Call them defectors. Speaker said, have you not read the verdict of the Goa bench? Then they went to the Goa bench. The Goa bench in 2025, that was last year, said, whatever we said in 2022, we stand by that. But by the 2025 Goa bench verdict, when it came, by then there was a Supreme Court verdict of 2023 related to Eknath Shinde taking away the members of the Thackeray party, that is the Shiv Sena. That was the Subhash Desai verdict of 2023. Very interesting. It had two parts. One part relates to the merger side of it. Another part is about political party, legislature party, chief whip. We are not interested in that part. We are interested in the merger part. What did the Subhash Desai verdict say about the merger? The merger paragraph, that is para 4, has to be read conjunctively. Subpara 1 leads to subpara 2. Unless the original political party decides to merge, the two-thirds members of the legislature party merging with another political party, the question does not arise. It is baseless. The foundation for subpara 2 is subpara 1, and therefore original political party merging with another political party decision, as in Praja Rajyam, is the basis, precondition for para 2 of subpara 2 operating. That was in 2023. In 2025, after Subhash Desai verdict was delivered by the Supreme Court of India, 5 judges unanimously, how could the Goa bench of the Bombay High Court continue with its earlier interpretation? That is when you tend to use the term per incuriam. Here is a verdict of a court fully overlooking the existing law or existing verdict of a higher court or a larger bench. You're overlooking Subhash Desai. You stuck to your own interpretation that you gave when there was no Supreme Court clarification about subpara 1, subpara 2 of para 4 dealing with merger. That is called per incuriam. A court giving its verdict fully overlooking, ignorant, or carelessly setting aside an existing, it could be out of ignorance or it could be otherwise, existing law or a verdict which is of a larger bench or which is of a higher court. So this is the Girish Chodankar verdict of the Goa bench of the Bombay High Court being in per incuriam. Now, the court takes up, Supreme Court is again going into the entire matter. There are 3 articles here. One is 132, 136 and 145. I want to discuss these articles because we are not only dealing with the merger part, we are also dealing with related phenomena, all of them being important for both your prelim and the main. And of course, those of you who are doing law, political science, public administration, for all of you this is very important. I notice some of you in your DAF also fill up current affairs, current constitutional developments, following the proceedings of the Supreme Court. These are some of the interests that you show in your DAF. For them, this is of vital importance. So 132 article says, if there is a substantive question of law requiring Supreme Court interpretation of the Constitution, requiring interpretation of the Constitution, in that case, if the High Court has to certify, imagine the Karnataka High Court and the Goa bench of the Bombay High Court saying 2 separate things about the anti-defection law. That means there is a substantive question of law requiring constitutional interpretation. High Court has to certify. Let this go to the Supreme Court. They will decide, they will settle the matter. 132. Then it goes to the Supreme Court. Because interpretation of the Constitution is involved, Article 145 says that a minimum 5-judge Constitution bench has to be set up. But no High Court has given such a certification here. Therefore, the matter had to be taken up by the Supreme Court under 136, special leave petition. So in December, the Supreme Court will start hearings. If they decide that a constitution bench has to be set up to go into the constitutionality and the actual position of para 4 of the anti-defection law, then they will set up a 5 or 7, whatever, judge constitution bench to go into it. We'll know it in the month of December. Now, I was telling you about disqualification and resignation. You know, disqualification can be for multiple reasons. Lalu Yadav has been disqualified under Section 8 of RPA 1951. That is a separate disqualification. And somebody else is disqualified because the accounts he presented of the election to the election commission were not fit and proper, and therefore they attracted disqualification with a separate set of consequences. But the least harmful disqualification is here. That is anti-defection law. One is a defector. Matter goes to the presiding officer, speaker or the chairperson. They act as a tribunal, and the tribunal decides that you should be disqualified. So what happens? According to the 91st Amendment Act 2003, if a legislator is disqualified under anti-defection law, he ceases to be a member, number one. He is unfit to be a minister, number two, and also he is unfit to hold any public post, number three, as long as he doesn't get re-elected in the by-election that will take place. Or, okay, he contests, but he is not elected. He is unfit, continues to be unfit all the way till the life of the house lasts. If it happens today, life of the house is going to end in 2029. Till then, he is not eligible to be a minister, etc., unless he gets re-elected. That is the consequence of disqualification. So he is too clever by half, over smart. He gives a resignation letter to the speaker. Sir, I am resigning. Speaker is handling a case related to his disqualification because of defection, but he would like to escape the consequences like I told you. Therefore, he wants to resign. If the speaker accepts the resignation, the speaker should convince himself that it is a voluntary resignation, there is no pressure on him, and if he is convinced, he will accept. If he accepts, then there will be a by-election, he can contest. And if he gets elected, everything is fine. Even before the by-election and being re-elected, the next day or the very same day, the day of acceptance of the resignation letter, he is eligible to be a minister, subject to being a member within 6 months. He can be the RTC chairperson, he can be any public sector holding chairperson, etc. So resignation is far, far better than disqualification due to defection. But the Karnataka High Court in 2019 said that in case a petition is pending for disqualification based on defection, the resignation issue does not arise. He cannot resign and get away. He has to wait for the verdict in the case of the defection based disqualification. That is disqualification versus resignation. So we have dealt with what is anti-defection law, how was it modified in 2003, 91st Amendment Act, and then we talked about who is exempt. We came across the fact that the split is no longer valid. We talked of para 4 of anti-defection law, the Goa bench of the Bombay High Court, Subhash Desai, both we have discussed. We also discussed the fact that under the special leave petition 136, a case is admitted by the Supreme Court in its discretionary capacity. It will hear in 2026 December about what exactly is the matter about para 4. That is another issue. Let me see if we have left out anything. Yes, all these issues are there. Aam Aadmi Party joins the merges in Rajya Sabha. And this also, Trinamool Congress we talked about, Shiv Sena we talked about. All this we have talked about exhaustively with additional phenomena related to constitution and law. Let's keep flipping these slides. Resignation, disqualification, we talked about it. You know, the famous judgment from the Karnataka High Court, Shrimanth Balasaheb Patil case 2019. Wherein it was said, while a case is pending against you for defection-based disqualification, you cannot entertain resignation. That option doesn't exist for you. And I have also mentioned the articles here. This is for Parliament, this is for state legislature. 132, 136 and 145, special leave petition, which is what is operational right now regarding this case. 145, we talked about it. 132, substantive question of law. Subhash Desai, very simple. Unless subpara 1 is kicked into action, subpara 2 does not exist. Subpara 1 comes into operation, 2 may go into operation. 1 doesn't come into operation, 2 is in a state of dormancy. It does not exist. Suspended animation. The suspended animation part of para 4, subpara 2, unsuspended can it become only when para 4, subpara 1 is activated. Very, very clear. I have made it the simplest. You can't come across a simpler version of it. With the help of the graphics and our explanation, you will be on top of the world about this matter. Bombay High Court Goa Bench 2025, they have said, we already said whatever we did in 2022, we stand by that. Based on that, the speaker also rejected your appeal that defection case be initiated against the Congress members that merged with the BJP. And they fell on deaf ears. And after the Subhash Desai verdict of 2023, the Bombay High Court Goa Bench continued to insist on what it said in 2022, and that may come in for severe criticism for non-application of mind. The consequences I have told you in detail. 91st, we talked about it in detail. Exemptions, that is how we began. This is where it is. So I've explained everything. In case of any doubt about it, here is your book. Go to book. This book should clarify everything you always wanted to know about the anti-defection law as it stands till today. I wish you all the best.